Hello viewers, welcome back to our YouTube channel. My name is Patra Alinda, a legal officer at Judicial Service Commission. Please subscribe if you haven't subscribed so that you do not miss any educational programs on law and administration of justice, as we'll continue to have them series in and series out. The last time we were here, we spoke about how to make a will, what must be in a valid will. Today we'll be looking at, in the unfortunate part, that the person has passed away and there was a will. What happens? How does the family and the family members move forward, execute this will? That is what we shall be discussing today. So first of all, we need to go back to our minds and know that the inevitable discussion of death, we have estates that we prepare or work for the benefit of our family members, the children and the spouses. You have the estate. What do I mean by the estate? You have movable and immovable property. Let's say cars, land, bicycles, animals, cattle. You have all these. You've worked and you have attained all these things, and you have made your will, as we discussed in our previous segment. Now, the unfortunate part has happened and you have passed away. What happens? Or your beloved one has passed away, they've left their will behind. The first thing that must be done is the person who was left in charge of this will must inform the family members. Notify the family members of the availability of this will. And this will should be verified by at least one of the witnesses that witnessed the will of the deceased while he or she was still alive, of their wishes that should be put into force. The moment the family members are notified, this will usually has an executor. Who is an executor? An executor is someone who has the instructions to perform or conduct whatever wishes are in this will. So the executor of this will must now go ahead and ensure they get authority to be able to execute and distribute the estate of the deceased. Now, there is a will, the family members are there is an estate that needs or requires to be distributed. You as an executor, you have the duty to ensure that you apply to court for grant of probate. Grant of probate is the authority to be able to distribute the estate of the deceased where there is existence of a will. What do you need? What are the most important documents that you must have before you can go to court to be able to be given the permission to distribute the estate of the deceased? First of all, you must have a death certificate of the deceased. How do you obtain this death certificate? First, if the person passed away at any medical facility, get a death notification record from that medical facility. If they did not, if they probably passed away maybe at home or in another place, you can get a death notification record from the sub-county chief or the town clerk. Once you have this death notification record, then you visit any near offices and you apply by paying a certain amount of money. It is usually 5,000 Uganda shillings, and you'll be able to attain the death certificate. Then equally obtain or make sure that you have a copy of the national identification card of the deceased person. You have your own national identification card and this will. We have circumstances where the will was written in a language that is not English. This will must be translated. So the translation of the will from the language it was written in, maybe Uganda, maybe actually into English, that translation must also be available. Once you have gathered all those documents, then you must prepare a petition. You can prepare this petition, or with the guidance of a lawyer, you can be able to come up with this petition. But we hope that from this video, you can be able to even sit down, you as an executor of this estate of the deceased, and be able to prepare one. Probably you can inquire from us in the comments if you do not understand some of these things, but we are simplifying some of these things so that you can be able to also attain a justice. So what must be in this petition? First of all, you need to identify what court am I going to. You're not just going to visit any court. If the person passed away maybe from massacre, you need to know what is the value of the estate that the deceased left behind. If the value of the estate, all the immovable and movable property amounts to 20 million and below, either 15 million or 10 million, then you can go to the magistrate grade 1 court within your area where the person passed away. If the value of this estate is either between 20 million to 50 million, but does not exceed 50 million, you can go to the chief magistrate's court in the area where the person passed away from or where they had their permanent address. And in case the value of the estate of the deceased was more than 50 million, then you will go to the high court of the area where the person passed away. If the person passed away in Barra, we don't expect you to go to the High Court of Cavalry to have this application made so that you can be granted letters of probate. We hope that you'll be able to visit the court where the death, within the area where the death occurred. So what must be in this petition? It is a document that must be addressed to the court, guided as per we have discussed, giving us the date when the deceased passed away. Now, that is why we were asking for the death certificate, because the death certificate notifies us of the date and even the cause of the death, even the location of the death. 2, you're going to list for us in that petition all the estate, all the properties and their value. If, for example, this person had land, you're going to be able to tell us this land, where is it registered or not registered, and what is its value. If the person has cattle, where are the said cattle? Are they in a certain farm? Are they in a neighbor's farm? If this person had probably money, is it in a certain bank account? Give us all the details in your petition that you're going to submit to court. Put the list of all the dependents. Who are the dependents of the deceased? Was he married? If he was married, the spouse, the name of the spouse, you must also attach a marriage certificate. The children, all the children. And we need to note that not only children that are in the marriage, even children, as long as the child belongs to you, as long as you're the actual parent of this child, that child must be listed in this petition. Then you as the applicant, you must inform court that actually the will appointed you as the one in charge of distributing the said estate. Then if you're going to the magistrate grade 1 court, you must also notify court that at the time of the death of this person, the person had the permanent address or was staying in that area of jurisdiction. Then you must also attach a certificate of compliance that you're going to be able to comply with all the laws. And then finally, you must attach the will, the death certificate, the national ID of the deceased, your national ID as an applicant, and submit to court. Court is going to handle this document, hear it, and will either grant you letters of probate or not. However, most definitely, if you follow these steps, court will be able to grant you letters of probate. Now, we need to know that once a person has passed on, you as an executor, you must be able to have or apply to court within 1 year. Make sure that you apply within 1 year so that letters of probate are granted to you so that you can be able to distribute the estate within the laws. And equally, this estate must be distributed within 2 years. And once you have distributed, you ought to go back to court and inform court of how you distributed the said estate and whether all the beneficiaries obtained as per the wishes of the deceased or not. You must also give reasons as to why. Now, we need to know this grant of probate, what is its authority? Once you have grant of probate or letters of probate, you as an executor, first of all, you have the authority to make sure that the estate is distributed as per the wishes of the deceased. Secondly, you can represent the estate in any legal proceedings, either against it or defending it. Now, there is an important thing that you should get away from today's segment. Prior to the amendment of the succession laws in Uganda, that was May 31st, 2023, all letters of probate were held in perpetuity. What do I mean? They were held for a lifetime. If you apply to court and you're granted these letters of probate, you would execute them for as long as you want. You can keep it and have it executed for as many years. But after the amendment, as of 31st May 2023, they now have a period within which they can get expired. So all the letters of probate that were obtained prior to May 31st of 2023, they have up to May 31st of 2025. After that, they will expire. So you can, if you have not distributed the estate of the deceased as per May 31st, 2025, please apply to court as soon as possible so that they can be extended, so that you can be able to distribute the said property. Otherwise, we know that estate is one of the areas where administration of justice is not seen to be done, because there are so many fraudulent, after the person has passed away, fraudulent schemes. So you have to be aware of this fact so that you do not have letters of probate that are invalid, and then you want to distribute the said estate to the dependents that were left behind, and then you find that someone else went and applied for the same letters of probate and they distributed to other people that are not the rightful dependents of the deceased. Now, as we finalize our segment today, you may have a question. What happens if there is a will, but the will did not name an executor? Or an executor was named, but immediately after the burial of the deceased, even this executor passed away. Or the will named so and so to execute the will on behalf of the family, but this executor has refused and they are saying they are unable to execute and distribute the estate of the deceased as per his or her wishes. Or even you've applied to court, you as an executor named in the will, and court has rejected granting you letters of probate. What happens in such scenarios? Now, if you are found in such a scenario, you can apply for letters of administration with a will annexed, and court will revisit your application and be able to consider whether to grant you letters of probate or not. But most definitely, they will grant you letters of probate if you have good reason as to and good intentions for the distribution of the estate of the deceased. I hope today we have learned one or two things. In case you have not yet subscribed, please subscribe. Continue to visit our YouTube channel so that you can be able to learn one or two things on the different segments on law and administration of justice that we'll continue to upload on our YouTube channel. Otherwise, thank you for watching. See you next time.